Well, good afternoon, everyone, and welcome to this seminar, this launch of the Council's report on sentencing outcomes for children held on remand in Victoria. Those of you who are joining, I can see the numbers creeping up on the screen, and so welcome to you all. I'm Arie Freiberg, I'm Chair of the Sentencing Advisory Council, and I'm joined today in giving this presentation by the project team who prepared this report. They're Paul McGorry, Manager, Legal Policy and Community Engagement, Zombal Bharti, Senior Data Analyst, and Octavian Simu, our Legal Policy Officer. But before we start, I'd like to acknowledge the traditional owners of the land on which the Council's office is located, the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders, past, present, and emerging. This is the Council's first online report launch, so bear with us if there are any technical glitches, but I think by now we're all getting used to this mode of communication. We intend to keep this presentation relatively brief, and in the interest of time, we won't be holding a Q&A session, but feel free to email Paul with any questions you may have, and his details will be provided to you on the last slide. We'll be recording and uploading this presentation on YouTube a little bit later on. So very briefly, what is remand? Well, just to set the scene for those joining us today who may not be familiar with the criminal justice procedure, anyone held in custody while awaiting trial for an alleged offence is being held on remand. A child held on remand has not yet been sentenced. The number of children held on remand on an average day in Victoria has doubled in the last decade, from 42 in 2008-9 to 90 in 2018-19. And remanded children now make up about half of all children in detention, about 47%, compared to 1 in 5 children in custody, or 22%, just 5 years ago. Why would we want to hold children on remand? Well, quite clearly and obviously, it's to reduce the risk to the community. Protection of the community plays a very strong role in bail decision-making, both for adults and for children. Indeed, last month, the Supreme Court failed or refused bail to a 15-year-old who was charged with committing a string of robberies while he was already on bail for other offences. And remand is also intended to ensure that a child will show up to court. Now, what are the arguments against holding children in remand? Well, clearly it interrupts social connections with friends, family, school, or employment, and for many at a crucial stage of their development. There's also a criminogenic effect due to interruption of support systems, stigmatisation, and exposure to negative social influences. And as well, and this is of interest, of course, to Treasury departments, remand is expensive. Recent estimates suggest it costs about $1,800 a day to hold a child in detention in Victoria. With about 90 children on remand on an average day, that means we're spending about $160,000 a day to hold children on remand. So what's the government doing? Well, pleasingly and most welcome, the Victorian government recently announced a youth justice strategic plan for the next 10 years. And that plan includes reducing the number of children held on remand, which they hope to achieve by identifying the drivers of the increase in remanded children and seeing if there are viable alternatives. And this is where this research comes in. So, what was this study about? Well, the main aim of the current project was to identify how many children held on remand actually end up getting a custodial sentence. And by doing that, especially by identifying which remanded children are least likely to receive a custodial sentence at the end of their case, it may be possible to identify some characteristics of certain children that make them ideal recipients for alternatives to remand. So now I'll hand over to the project team to take you through the main findings and policy implications of the Council's research.
How did we arrive at the data set used in the project? The Council identified all children held on remand for at least one day in 2017-18. This data came from Youth Justice. The Council also identified all outcomes for children imposed between July 2017 and June 2019. This data came from the Children's Court. We then manually matched remand cases to court hearings by first linking the children's identities between the two data sets and then matching the offences at remand to the offences at court. In many cases, this was a complex initiative in that a child's court case did not immediately follow their remand period starting or ending. We were able to identify the court outcomes for 99% of the remand cases. Following those steps, we identified 442 children who spent at least one day in remand in 2017-18. These children were held on remand for 660 cases in total. This means that some children were released from remand and returned within the same year. In fact, 150 children had more than one remand case in 2017-18. The cohort was predominantly male, 89%, and most of the cohort was aged 16 or 17 years old, 59%. Of the 442 children in the index population, 433 self-reported their ethnicity. The most common ethnicities were non-Indigenous Australian, Aboriginal and Torres Strait Islander, New Zealander, Maori and Pacifica, Sudanese, and Horn African. As these proportions show, children from Indigenous and culturally and linguistically diverse backgrounds were significantly overrepresented among remanded children. For example, people who identify as Aboriginal and Torres Strait Islander represent less than 1% of the Victorian population. This is consistent with other research that found that South Sudanese and Pacifica young people are the most likely groups to have contact with police in Victoria. An interesting finding was that a great majority of remandees had had some contact with the justice system before their remand case analysed for this project. Within the 94% of remandees with some prior contact, 2/3 had been previously sentenced for other offending, 4/5 had ongoing proceedings at the time of their remand period analysed for this project, and 2/5 had spent time on remand prior to our reference period. That such a high proportion of remanded children had prior contact with the justice system is a good sign that remand is generally not the first option for decision makers, and children with no prior contact are much less likely to be remanded.
So with that in mind, let's have a look at the kind of offending that these children were remanded for. Looking at what was the most serious offence in each case, let's just get a sense of the type of offending involved in the case. And we worked this out by looking at which offence in the case had the highest maximum penalty. We found that children were most commonly going on remand for robbery, such as armed robbery or carjacking, 28% of cases, theft-related offending, such as thefts of motor vehicles, 23%, and burglary, including home invasions, 21%. We also analysed how prevalent certain offences were across all cases for which children were remanded. And the most common offence categories in remanded children's cases were theft and related offending, which featured in 65% of cases, breaches of bail and other court orders in 62% of cases, and offences against the person, such as assaults in 38% of cases. Robbery and burglary offences were up next and equally featured in 32% of cases. Now let's answer the first of those main research questions that Arie noted a moment ago. How many remanded children received a custodial sentence? This graph compares the remanded children's outcomes with all outcomes in the Children's Court in 2017-18. The children that received custodial sentences are represented in the middle grouping here. As you can see, the answer is that 1/3, or 34% to be exact, of remanded children received a custodial sentence. That 34% is made up of 5% that received a custodial sentence that amounted to time spent on remand, meaning they were released after being sentenced, and 29% that was sentenced to more time in custody. This means that, on the other hand, 2/3 of children that were on remand did not ultimately receive a custodial sentence. 58% of children got a community order, such as a youth supervision order. However, when compared to all children sentenced in the Children's Court, remanded children were 5 times more likely to receive a custodial sentence. It's important to bear in mind that a child can be remanded without ever having applied for bail. So it's not necessarily the case that all of these children were denied bail. In that context, the report includes an overview of how many children, when they first appeared before a court after police decided against bailing them, actually applied for bail. And it made for perhaps one of the most interesting findings in the report. Looking at the last 5 financial years, children did not apply for bail in between 52% to 65% of initial bail hearings before the Children's Court. And we got this data from the Department of Justice and Community Safety, and it doesn't include bail justice decisions. Why are so many children not applying for bail? In consultations, we heard that one common explanation is that the child simply doesn't think they would be granted bail. Meanwhile, this data shows that where a child does make an application, they're about 4 times as likely to be granted bail than they are to be refused bail. For instance, in 2018-19, of the 2,050 children who did apply for bail at first instance, 82% were granted bail, while only 18% were refused bail. Another important thing to consider is that there are a number of factors that are relevant to determining whether a child poses an unacceptable risk and therefore must be refused bail, beyond just the seriousness of the alleged offending. Indeed, a child's particular circumstances at the time of the bail hearing can have a direct impact on their suitability for bail. Things like appropriate accommodation and bail supervision programs are often important responses to the child's circumstances. And naturally, it takes some time to set those things up. However, once in place, they make releasing the child on bail before their case is finalised a much more viable option. In this way, we found that more than half, 53% of all remanded children were released on bail before their case was finalised. What's more, of those children that stayed on remand until the end of their case, more than half were released upon being sentenced, either because they received a non-custodial sentence, they received a custodial sentence amounting to time already served, or proceedings otherwise came to an end. For example, because all charges were found not proven. This means that in total, 20% of remanded children entered remand, stayed there, and upon being given a custodial sentence with more time to serve, entered sentence detention. And this breakdown is reflected in the durations of the remand episodes, as you can see on screen here. Nearly a quarter of all remanded children spent only 1 week or less on remand, with the majority of those short remand episodes ending because the child was released on bail. As Paul will mention in a moment, being released on bail made a remanded child significantly less likely to receive a custodial sentence. Being released on bail, even at a later stage, would suggest that the child's circumstances or offending were not of the most serious kind, meaning in turn that non-custodial options would be a more realistic proposition for a court that eventually has to sentence the child. These remand duration figures raise the very important issue of resourcing once again. Remanded children spent in total almost 29,000 days on remand at an estimated taxpayer cost of $41 million. That's an average of $93,000 per child. Remanded children sentenced to custody, that is the 34% of remanded children, spent 18,000 days on remand, costing approximately $26 million. Meanwhile, remanded children that were not sentenced to custody, the remaining 2/3, spent around 11,000 days on remand, costing approximately $15 million.
So Arie mentioned at the beginning that one of the primary aims of this research was to understand whether some children were noticeably more or less likely to receive a custodial sentence than other children, which would make them ideal targets for any initiatives designed to reduce the number of children held on remand. Of the 442 remanded children in our research, there was almost no variation in the likelihood of them receiving a custodial sentence based on their demographic characteristics or who made the initial decision to remand them after they'd been refused bail by police. In particular, there was very little variation in the rate of custodial sentences imposed on children based on their age. 14 and 15-year-olds were almost exactly as likely to receive a custodial sentence as 16 and 17-year-olds. Male and female children were equally as likely to receive a custodial sentence. Children from various backgrounds received the same rate of custodial sentences. For instance, 16% of all custodial sentences imposed on remanded children were imposed on Aboriginal and Torres Strait Islander children, who made up 15% of the remand population. This isn't to say that they weren't severely overrepresented in the remand population, only that at sentencing they were just as likely to receive a custodial sentence as other children. Similarly, children first remanded by a bail justice were just as likely to receive a custodial sentence as children who were first remanded by a court. Now, this actually runs contrary to the common perception that bail justices are overly risk-averse and rubber-stamp police decisions. There were, however, some factors that were associated with a lower likelihood of receiving a custodial sentence, many of which won't be surprising, but some will. First, children bailed before the end of their case were a quarter as likely to get a custodial sentence as those who weren't. That is, 15% of bailed children got a custodial sentence compared to 55% of children who were held on remand until the end of their case. Second, the less time a child was held on remand, the less likely they were to receive a custodial sentence. As you can see on the graph here, of children remanded for a week or less at the far left, just 9% ended up receiving a custodial sentence. Over the next 6 weeks, that 9% gradually increased, and between weeks 6 and 7 in particular, the likelihood of receiving a custodial sentence jumped from 33% to 52%. Third, children who had previously been remanded or sentenced were substantially more likely to receive a custodial sentence. For instance, 42% of children who had been sentenced previously before they were remanded received a custodial sentence, and that's more than twice the rate, 18%, of children who hadn't previously been sentenced. And even more telling, children who had been remanded previously were 4 times as likely to receive a custodial sentence as those who hadn't, 57% compared to 15%. In a way, this is good news. Much as Jean-Paul pointed out earlier, it means the system isn't simply throwing the book at first-time offenders. Finally, children whose most serious offence was either a threat offence or a property damage offence were much less likely than children charged with other offence types, such as assaults, robberies, and burglaries, to receive a custodial sentence. While there's no way to tell definitively from our data, it's likely that a number of these children were living in out-of-home care arrangements. Both property damage and threatening behaviours are trauma-related behaviours that are more likely to prompt a police response in out-of-home context than they might have if the child had been living in the family home. So what do all these findings mean? We've got 3 quick slides before we wrap up. The first implication of these findings is that some children are especially vulnerable to the remand experience, but for different reasons. Aboriginal and Torres Strait Islander children were significantly overrepresented in the remand population, at more than 15 times their prevalence in the general community. Female children were more likely to be remanded younger and tended to be remanded for less serious offending than male children. For instance, while female children were more likely to be remanded for theft offending, male children were much more likely to instead be remanded for robberies. Children remanded in rural and regional areas, and on this graph that's everywhere other than the Melbourne metropolitan area, were more likely to be female, Indigenous, and receive a custodial sentence, whereas their urban counterparts were instead more likely to be male, non-Indigenous, and receive a non-custodial sentence, like a youth supervision order. And children aged under 14 were 15 times more likely to have all their charges withdrawn or dismissed than older children. Of the 40 cases where a child was remanded while under the age of 14, more than a third of those ended when all of the charges were withdrawn or dismissed. By comparison, just 2% of cases involving older children resulted in no proven charges. Next, to improve outcomes for children in rural and regional areas and Aboriginal and Torres Strait Islander children, the Council raises the possible desirability of expanding the Specialised Children's Court in Melbourne with specialised judicial officers and support services to rural and regional headquarter courts, and also ensuring that programs are designed specifically for and with Aboriginal and Torres Strait Islander children to help them avoid the remand experience and reduce their significant overrepresentation. Lastly, the Council raises the possibility of a fully resourced, 24-hour, Victoria-wide bail system specifically for children. We saw a lot of children being held on remand for very short periods. A quarter were held for less than a week. What we heard from stakeholders we spoke to was that often the services aren't available at the time the decision has to be made to bail or remand the child. That could include youth justice support workers to write reports for the decision maker about what programs might be available, housing support services to make sure there's somewhere safe and appropriate for the child to live if they're bailed, legal representation and other independent persons to support children during their initial bail hearings, and above all else, of course, someone to actually make the decision. Nearly 4 in 5 children enter remand outside of court operating hours. And while there are far fewer bail justices operating today than there were just a few years ago, we found that they're still making the slim majority of bail decisions for children because a court simply isn't available, usually because it's either the weekend or otherwise outside of business hours. Given the significant cost of remanding children, both in the short and long term, a holistic, around-the-clock bail system, specifically for children, could actually save money and make the community safer. Now, we'd be remiss not to thank both the Department of Justice and the courts for providing the data on which this report was based, as well as the stakeholders who attended our roundtables that we held a couple of months ago. What you can see here on the slide are just some of the key quotes from youth justice stakeholders across Victoria that we spoke to. I don't expect you'll have time to read and digest all of these right now, but really the key thing to get from this slide is that there was near unanimous support for the introduction of a bail system specifically for kids that operates 24 hours a day. 2 people at separate roundtables described that sort of reform as a no-brainer. So that's it from us. I encourage everyone here to download a copy of the report from our website, which has all the findings we've talked about today, as well as much more, as well as the 2-page fact sheet, which is also available on the website. We haven't included a Q&A component in today's session, in large part because this was our first attempt at an online launch and we wanted to learn to walk before we ran. We do, though, hope to bring that feature into future report launches. That said, if you do have any questions arising from today's presentation, please feel free to get in contact. You can send an email to me using the email address here on the screen. Please feel free to take a screenshot, or you can also get in contact through our website. Otherwise, I'd like to thank everyone who took time out of their busy day to attend today's session, and I hope everyone has a lovely afternoon.